Planning Commission meeting to order. Are there any changes to the agenda? All right.
Motion to accept the agenda.
Second.
All right, all in favor? All right. Any changes to the minutes?
I'll make a motion to approve the minutes.
I'll
Second.
All right, all in favor? All right, first item on the agenda is an administrative appeal of the zoning administrator's decision to classify the division of tax map number 581-00-00-06 as a major subdivision. I'd like to open us up for public hearing, and I'd like to call the applicant forward to get us started with that. All right, and before you get started, if you could just state your name and your address.
Thank you. Thank you, Mr. Chair. Dan Ballou, 417 Windsor Terrace in Rock Hill, here on behalf of my client, the applicant for a plat, exempt plat approval that was denied by staff. The question I want to pose to y'all as the Planning Commission tonight, it's a little bit rhetorical, but when is a subdivision not a subdivision? Because I think the definitions matter, and the reasoning that staff applied to this matters, because the reasoning is not consistent, in fact conflicts with the Enabling Act, the statutory authority that created this body and creates the authority for this body and for the county to adopt the land development regulations as a whole. So our position is that you are bound certainly by your ordinance, but you're also bound by state law that applies to these kinds of situations, and that's what we want to talk about tonight. So the property in question is contained within the appeal application. It's in the Legacy Park area. It was previously owned by Duke Energy. It was acquired by my client approximately almost a year ago. And they had submitted a plat that showed, it was entitled an exempt plat, and that it showed lots that were more than 5 acres in size, and that no new roads were involved. And under the applicable statute, under the Enabling Act, that is an exempt plat. It is accepted from the definition of a subdivision. We can talk about that in a minute. We'll walk through that definition. We believe there was error in the denial of this because the error was based upon the position that was presented by the planning director, by Ms. Grothe, that considered this a minor subdivision. And I'll submit to you that under the ordinance, this is not a minor subdivision. And it's certainly not a major subdivision. And so let's go back to the original question. When is a subdivision not a subdivision? And I suggest the answer is when it's an exempt subdivision. And the General Assembly was very clear when it adopted the Enabling Act that underpins all of the planning regulations and ordinances throughout the state, frankly. And it defines subdivision, and it says subdivision is any division of land, and it goes through a variety of situations where you're dividing land in what we all can consider to be a traditional subdivision. But then it has some curious language, and this is in section 6-29-1110 of the South Carolina Code. That's the Enabling Act. That's what I've referred to as the act that underpins the ordinance. And it says under subsection 4 of that, the following exceptions are included within this definition only for the purpose of requiring that the local planning agency be informed and have a record of the subdivisions. And the second of these accepted or exempted subdivisions of land is the division of land into parcels of 5 acres or more, where no new street is involved, and the plats of these exceptions must be received as information by the planning agency which shall indicate that fact on the plats. So it not only modifies the definition of a subdivision and creates this special category of exempt subdivision, but then it says, not only that, but here's all you can do with it, which only for the purpose of requiring the local planning agency be informed and have a record, and that the plat must be received, must, as information by the planning agency, which shall indicate that fact on the plats. And so when we submit the plat in this case, it was originally approximately 20-acre parcel that we asked for it to be subdivided into 4 lots of more than 5 acres each. And our position is very simple, that is under the ordinance and under the enabling act, that is an exempt plat. That is an exempt subdivision. That is a specifically carved out category of subdivision that simply doesn't apply, like the ordinance doesn't apply to that like it would apply to a minor subdivision as defined by the ordinance, or a major subdivision as defined by the ordinance. The ordinance clearly says major subdivision, all the provisions of the ordinance apply. Minor subdivision, certain provisions don't apply, but everything else does apply. But it doesn't say that the exempt plat as defined by statute is a minor subdivision. So first of all, it's error to consider it a minor subdivision. It shouldn't be treated as a minor subdivision. This is a situation where it's not necessarily a conflict between the ordinance and the statute. It's just not addressed. The issue of the exempt plat as defined by the Enabling Act is really not specified in the ordinance. And so I think it's your job to meld these together. How do you make sense of these different rules that apply to the situation? Our position is, look, you've got to go with what the General Assembly tells you. They're the governing body that enables the county to adopt these kinds of ordinances. And then you fill in the gaps with what your ordinance says, but you can't contradict what the General Assembly said. You can supplement, I think the General Assembly intended to give counties a lot of leeway in how they draft their ordinances. And there's a lot of reason for that, because there's a lot of deference, frankly, given to counties to how they draft their ordinances. But there are certain circumstances where there are specific definitions and specific requirements and specific limitations that the General Assembly decided it needed to control. And one of those is this definition of subdivision. So when you look at section 629.1110, subsection 4, that controls, in our opinion. That is something that you're not free to disregard. You can't just make up the definition of subdivision irrespective of what the General Assembly defined it to be. And so you have to be able to reconcile these. And our position would be that this is, in fact, a exempt subdivision. It's an exempt plat. It should be received as information. It should be recorded, and the property owner should be allowed to have that subdivision. Now, there are, in my appeal, I cited a case from the Court of Appeals, South Carolina Court of Appeals out of Beaufort County. And I'll note that in Beaufort County, the court in that case had a situation where a property owner submitted a plat that was exempt under this exact statute, and the county recorded it and noted it for the record, and then it was appealed by an environmental group who had some questions about what the use of the property was. The court ultimately concluded they didn't have standing to contest it, but they specifically acknowledged that this statute was adopted specifically for this purpose, and that the county's ordinance followed that statute. Like I said, I don't think this is necessarily a conflict between the York County Land Development Code and the statute. I think there's a gap there that needs to be filled. But Beaufort County has specifically created in its ordinance exempt plats. And sure enough, the definitions from the statute flow into the ordinance. So to the extent that there's some correction that ultimately the county attorney would need to recommend to county council to amend that ordinance, There are certainly examples all over the state: Greenville County, Richland County, Charleston County, Lancaster County. They all have categories of exempt plats that follow this statute. And I would suggest to you that's the right approach, that provides for the orderly and consistent development of property. These are large lots, 5 acres or more. No new roads are involved. It should be relatively straightforward, and I think that's what the General Assembly intended. It should be something that should be received as information, and then you move on with it. Now, they've still got to go through plat approval. If someone wants to develop it, that's a different question. We're talking about subdivision. This is a subdivision issue. And our position is that staff misinterpreted the ordinance, that they tried to shoehorn this situation into the language that they did have under a minor subdivision. I don't think there's any question this is not a minor subdivision. It doesn't fit that definition. And certainly not a major subdivision because there's no new roads. So that's our position. We're not, we think this is fairly straightforward. I think this is something that is a question that this planning commission can correct. You can overturn the interpretation of staff. You can make a determination that is consistent with both the ordinance and the statute, and we think that's what you should do.
All right. Any questions for the applicant?
Yes, sir.
Maybe two. So in this particular case, we are only looking at, and for your reference, I don't know if you have the letter from Rachel
I do.
Groth? Okay. So there's 6 properties listed on that letter.
That's right.
All right. And so we're only talking about one of these 6.
We'd only submitted for lot 2 as defined on this letter.
Okay. And if I've understood what you've explained to us is your interpretation and how you see the state statute,
Yes, sir.
there would be an opportunity to do the same thing in 2 more sections here. Is that correct?
Well, to the extent that you are creating lots that are more than 5 acres, that's what the statute would allow.
Right. So that would let you, if you stayed at 5 acres, you would be doing 4 in lot 2. You could do 3 in lot 6, and you could do 5 more in lot 5. Would that be your understanding?
Theoretically, I think that's what the statute
Okay.
allows.
And so is that the plan of what will be happening down the road?
We don't know that.
Don't know that, okay. The other question that I had about this is, and I'm sorry, bear with me just a minute. There's a lot of information in here. The reference to the minor subdivision, which is, I'm trying to get the right thing here. The county code has that, correct?
Yes, sir. That is 154-490.
Okay, so
Defined terms.
in what you are stating here, are you saying that minor subdivision code should not even be in existence as part of the county code?
Not at all. I'm not saying that at all.
Okay,
I'm saying that the county can certainly define non-exempt subdivisions into major and minor, and that makes perfect sense.
okay,
But when you apply the definition of an exempt subdivision to that, it really only makes sense if you exempt it. You have a special process, which is an abbreviated filing for informational purposes only for those qualifying exempt plats. But for all other development, you go by your ordinance.
okay. I think I understand. Thank you, sir.
Thank you.
Are there any other questions for the applicant? All right, thank you, sir.
Thank you.
Yeah, not
Oh.
at this time.
Okay. Thank you.
Okay, thank you.
All right.
Hi there. I'm Rachel Grothy, the zoning administrator. And so I guess sort of piggybacking off what Mr. Ballou indicated, the There were just a couple of things I wanted to clarify before I jumped fully into the presentation, and that has to do with the case that he cited. So actually, in that particular case, the BZA, so the Board of Zoning Appeals, found that the zoning administrator should not have approved that plat for recordation that he referenced. Further, the court did not decide in that case who was correct. So I just wanted to put that out there. Okay, so in February of 2020, the Planning Commission conditionally approved a preliminary plat for the peninsula at Lake Wylie. So this involved the division of 4 large tracts of land, which you see here, which was comprised of 348 acres. And so dividing that into 161 lots. Ultimately, that project did not move forward. And then in July of 2022, staff administratively approved the division of each of the 4 tracts into minor subdivisions not to exceed 6 lots each. So this appeal is centered around one of the 6 lots that was created in Tract 1, which I have outlined there in red. So I guess the way I've been thinking about this is like starting very big and then narrowing down. So Tract 1 was a 92.45 acre parcel that was administratively approved by staff in July of 2022 to be divided into the 6 lots shown here. The parcel at the center of this appeal is the hatched one up at the top that fronts on Concord Road. So this is the 20-acre parcel that the applicant is proposing to divide into the 4 5-acre lots. So here is a close-up of the 20-acre parcel that the applicant submitted as a minor subdivision earlier this year. So staff denied the individual plat in February as the proposed project or proposed division of the lot was, wait one second. Staff denied the individual plat in February as the proposed project was a further division of a lot that was created by a minor subdivision. So that was the 6 lots that were created in July of 2022. Approval of this would be in direct conflict with what the Land Development Code defines as a minor subdivision, 6 lots or less. So the code is very clear on this. Lots from a minor subdivision cannot be re-subdivided to create another minor subdivision. Staff informed the applicant that the project would require preliminary plat and approval by this commission. So the Land Development Code defines minor subdivision of a subdivision of not more than 6 lots that does not involve the construction of new streets or improvements to an existing street. Resultant lots of a minor subdivision, including the parent parcel, cannot be re-subdivided into another minor subdivision. So in reading this definition, this is precisely what the applicant is proposing to do. Re-subdivide a previous minor subdivision into another minor subdivision. And then moving on to definition of a major subdivision. The Land Development Code defines it as any subdivision of 7 or more lots that involves the construction of new streets or improvements to an existing street. These subdivisions require preliminary plats to be reviewed and approved by the Planning Department and brought forward to the Planning Commission. So based on the previous division of Tract 1 into 6 lots, the proposed division of Lot 2 would create a total of 9 lots. This exceeds the number of lots permitted under a minor subdivision. So I want to be really clear about this. The applicant does have the ability to utilize their property and move forward with their subdivision. However, approval by this commission is required first. So it's worth noting that this commission recently approved, I think it was probably just a couple months ago, recently approved a preliminary plat that was not dissimilar to this proposed division, which was Mimosa Farms. And that involved the creation of 10 5-acre lots. Preliminary plats of this nature, lots greater than 5 acres that does not involve the construction of new streets, are exempt from subchapter B, which are design standards, and subchapter C, which are infrastructure standards. So just because the proposed lots are greater than 5 acres does not mean that it is no longer classified as a major subdivision. The proposed plat does involve new streets. What's shown on the plat are yet to be constructed roads located in platted and recorded rights-of-way. However, there are also depicted rudimentary access ways that meander in and out of the platted right-of-ways. Therefore, due to these reserved public rights, the conflicting access ways to the proposed lots, and the unconstructed status of the streets that will impact the proposed lots, it is evident that new streets are in fact involved in this proposal. So let's talk a little bit about what your role here is tonight. So the Planning Commission is empowered by the Land Development Code to hear appeals of a determination in the enforcement of the Land Development Code. So the commission may reverse, affirm, wholly impart, or may modify the determination. And that was the letter that was sent to Mr. Ballou, I think dated March 30th. So this concludes staff presentation on this matter. We ask that you affirm the administrative decision outlined in that March 30th letter, that the proposed division of a previously approved minor subdivision must be approved by the commission as a preliminary plat. I'm available for any questions that y'all may have.
All right. Any questions for staff? No? Go ahead.
First of all, I think I mispronounced your name. It's Grothy.
It's growthy.
I'm
My whole
sorry
life,
for
it's
leaving.
okay.
I'm sorry. Well, if you read mine, it's not been easy for me either. Would you go back to the picture of the various pieces of property again?
Tell me when.
One more. Okay. So this is the 6th of the minor subdivision that we're talking about. Is that correct?
That's correct.
Okay. And when this was approved, was that approved for a different owner of the property than the gentleman that owns the property now?
Not that I'm aware of.
Okay, but
you'll
they're
have
both
to-
shaking their heads yes. So at the time that the minor subdivision was approved, it was not to the property owner that currently owns the property. Okay, all right. I wanted to clarify that. And then the only one that we're talking about trying to further divide is the one that is shaded.
That's correct.
The
That's-
rest of them, there's been no discussion, but there are a couple of parcels that their size would permit that
Yes.
to happen.
Yes,
But again, they would be in the same situation because they would be subdividing in a minor subdivision for those other parcels as well, right?
that's correct.
Okay.
And I think you addressed this earlier in the applicant's presentation. And sort of like the thought that I have about it is, okay, well, when does this stop? Like, how many lots are you going to end up creating? Not just for this parcel in particular, but other large tracts of land. Like, when does that stop, and when do we start looking at new roads and looking at the
Right.
circulation
Right.
network?
And I guess I would ask another clarifying question around that. So we have subdivisions in the county that are a lot less than 5 acres each, based on different zoning and what's allowed to be done. So I haven't seen anything that showed what the zoning of all of this is. Did do you or Diane or Jonathan or anyone know what these particular pieces of property are
I
zoned?
think they're all RMX 10.
RMX 20.
RMX 20, okay,
They're RMX 10.
RMX 10,
okay, so here we
which
go.
is residential, mixed use, 10,000.
10,000 square feet, right? And so that's a much smaller than 5 acres.
That's correct.
So what prevents this from going from 5 acres down to however many you can fit at 10,000 square feet?
Water and sewer.
The lack of water and sewer.
The lack of water and sewer, is that
Yeah,
it?
so this came
right?
before us, I think before you were on commission for the 100 and some odd lots.
Right,
And they had to have community septic, multiple community septics, because they wouldn't perk even at an acre
okay.
per. So that's
So
kind of
that's
where
part of what's tied into how we got to these size pieces and that sort
Right.
of thing.
And the subdivision runs with the land, not the owner, because I know you were asking about who owned it before. So
Correct.
the subdivision runs with, it doesn't matter who owned it before, who owns
Right,
it now.
right.
and
No,
who
I
owns
was
it
more
next.
interested in, had this all division happened at another owner's request, well, okay, once they do that, then the next owner has it,
Right.
and that's what it is, but I was just curious who had begun the process, that's all.
Perfect.
Thank you for keeping me straight, and thank you very much for the questions.
Yeah, you're welcome. Any other questions? Okay.
Any questions? All right. All right.
Real briefly in rebuttal, and I think the issue before you, as Ms. Grothy clearly stated, is that they interpret this as a minor subdivision. And the difference is the minor subdivision is defined by the number of lots. The exempt subdivision is defined by the size of the lots. That's why they're not the same thing. This was not submitted by my client as a minor subdivision. It was submitted as an exempt subdivision. It was treated as a minor subdivision because they wanted to fit it into this minor subdivision definition. But that's not, in reality, what the request is. And in fact, all of those lots do have access to existing roads. So we are not contemplating constructing any new roads. If you look at that map, they all have access to either Concord Road or the side road coming down. And then to answer the question, where does it stop? First of all, that's a question for the General Assembly, because I think they're the ones that created this issue in the first place, and one that we think makes sense. But the answer is at 5 acres. If you can submit exempt plats that otherwise meet the statute, that are 5 acres or more, and that don't involve creation of new roads, they're exempt. I think that's pretty clear from what the statute says. So that's how we simply be asked to be treated. This is the same issue that applies not just in York County, but in Beaufort, Greenville, Richland, Charleston, every other county in the state. This is a question of statutory construction. It's a question for this planning commission to interpret what the legislature has given you with what county council's given you in a way that makes most sense. So,
Thanks, sir.
Okay, I have a question.
Yes, sir.
So if you don't believe this involves new streets then their explanation that yet to be constructed roads and platted and recorded right-of-ways, and it depicts rudimentary access, and it even shows on this plat how a gravel drive is meandering within and outside the right-of-way. How would that be corrected then?
I think that's something you have to go through in the plat approval process. I think that's not a subdivision issue. I think that's something
But
that
if
when
it's,
you,
so if you just said it right there, it's a plat approval process. So it has to be, so something has to be presented that staff can review and approve. So how can it be exempt if they have to approve it at the same time?
well, because if it was exempt at the time that it was subdivided, and now the property owner is then asking for access on a new road, then you'll have to go through that process. That's different than what is prescribed by the subdivision process. So these lots all have access. They all have frontage. They all have sufficient frontage on existing roads. We think they fit cleanly within the statute, and we just ask they be treated that way under the ordinance.
So do you believe the staff has the or do you believe the county has the latitude to dictate their own rules?
Sure.
Okay,
Courts have said that repeatedly.
okay, so,
But they can't make up their rules. They can't make up rules that are different than what the General Assembly has dictated.
correct. And, I mean, it also says in the state rules that once a local governing authority has adopted land development regulations, no subdivision plat or other land development plans within the jurisdiction may be filed or recorded until it's been, approved by the jurisdiction itself.
Exactly. And our position
So it
is
has to
these
be
are exempt.
approved.
These are legitimate, should be acceptable under the statute. They should be recorded. We should move on.
But it needs to be reviewed and approved by the jurisdiction.
But that's where, that's where I think the interpretation is, what is the latitude of the administrator when they're presented with an exempt plat? And the statute says it's provided for information only and recorded. Now, if you get below that 5-acre threshold, then you are cleanly within your minor subdivision or your major subdivision, depending on whether you've got new roads or not, or whatever factors might apply. This is a very narrow situation in terms of the size of the lots. And again, the exemption goes to the size, not the number.
Any other questions for the applicant?
I don't have anything else that I can think of right now.
Okay. Thank you.
All right. All right. Is there anyone that's would like to speak that's in favor of staff's determination?
Explain that, in favor of their determination, which was to disallow the appeal?
I can't. Yes.
Then yes, I would
Yeah.
like.
Can you come up and state your name and address?
My name is Mark Sleeper, 3872 Concord Road in York. I live right off of Concord that we're talking about. Yes, I support staff's recommendations fully to vote against the appeal. And furthermore, as a resident, I strongly urge you to deny any further subdivisions. And that's where I think we're going here. Let me back up just a little bit, though, if you don't mind. Some of you, Ms. Hendrickson, I know, and some of you have heard us come before the county, the Planning Commission before. We've been involved in the sale of this 548 acres since 2004, when Duke first put it up for sale. And we have not opposed it. I want to be very clear about that. We've never opposed the sale of it. We want to assure safeguards. We've got over 100 residents down there. We have all sent, many of us have sent you emails that have probably stated some of this that you've already heard, so I'm going to briefly say it, I'll try to keep it short. Safety is our #1 concern. Everything they're talking about, all the legalities, the staff is really well documented, and that's not something I can speak to. I'm not a lawyer, but I live there. I can tell you that we have a unique situation on our peninsula. He admitted that you have, as a commission, leeway to interpret these laws. Blessings to you to interpret the legal aspect of it. But let me tell you, I've got a nuclear plant that if there's a problem on that nuclear plant, we've got 150 residents probably that need to get out of there. We've got a 1-lane bridge, or a 2-lane, two-lane bridge to evacuate past the problem if the nuclear plant's having an emergency. So it's been priority #1 of our group, which is just the citizens that live down there, to try to keep density low. Originally, you may not be aware, in 2004, the original plats were 340-some lots. And we've been before numerous groups of commissions to try to, we talked about with the the York County Safety, I'm drawing a blank. Cotton Howell used to be chairman of it, to try to get them to
It's
say.
emergency management.
Thank you, Emergency Management Commission. And we've had them come down, look at it. They've always said, yes, it's a problem. Yes, it needs to be addressed, but we can't do anything for you guys until there's a concrete plan in place. They said, yeah, 348 homes is ridiculous. Actually, before that, it was the option of having multifamily homes in there because of the zoning that it is. Because of the overlay, we've eliminated that problem, or it has been eliminated for us. So now, when it finally came down to 4 lots, 6 each, Titan has even said, hey, you won. Why are you arguing about this? This is why we're arguing and concerned about it, is because, just like Ms. Grothe said, when's it going to end? They bought these lots knowing that they couldn't subdivide any further, and now they're going to start appealing. And I don't know, but it sure sounds like they'll probably do it with all other lots in there too, all 27 lots or however many there are. You asked the question, sir, about who's the current, or if this was done under the current property owner. They said no, but you know the original property owners was Duke. Then there was Premier. Then there was BWE, and now there's Titan. So they're correct that it wasn't maybe under Titan. I don't know. But guess what? BWE and Premier and Titan are all the same. They are in the same office, the same building, same address. I'm sure there's a legal, technical reason why they're different, but they're the same entity. So safety is our #1 concern. We're in zone A0, which is ground zero for the nuclear plant. When that nuclear plant was built in 1979, I think, it was in their charter to have a safety zone around it. That's why there's low density in there right now, and that's what we're trying to maintain. The other thing that is unique about it is the environmentally sensitive area. It's a peninsula, unlike a lot of other developments you have in York County. I understand where high density needs to be. That's great. But it doesn't need to be out on a peninsula surrounded on 3 sides by Lake Wylie for water quality issues. Once they start building roads in there and putting high density development, there's going to be spills just like there is in many other places on the lake. So environmentally, it's very unique. Like I said, the staff has outlined all the legal arguments. It's still in Titan's name, and that's what it was last I saw when it was developed like this. So I don't know who originally did it, but it should be a real simple decision, as they have laid out, of why this shouldn't be subdivided further again and again and again. One of the reasons, like Ms. Hendrickson said, that the 161 lots wasn't economically feasible because they couldn't put water and sewer across the bridge. So now they've got to do it individually. Then when they went in there to perk all those 161 lots, a lot of them didn't perk. So they came up with a shared septic idea, which was absolutely unacceptable. It never went to South Carolina DHEC for approval. And one of the reasons was because you guys were wise enough to give them some other roadblocks to, well, you know what, we can't allow right-of-ways, so that's going to kind of hinder it. So I'm sure economically that didn't work. So what I believe, just a guess, that they said, let's do what we know will get passed, and then we're going to come back to you and try to appeal every dang lot in there and try to get more high density. So that's something we're very concerned about as residents. One last thing, just to make you aware of, I'm being sued by Titan. It's not through Morton and Getty, because they singled me out, I guess because I put out a lot of emails and try to put out factual information, and of course they're denying that what I've said is factual. So we'll let the lawyers deal with that. But my point is, as soon as I got sued, got the summons, wait a minute, don't tell me. Just want to get your name right. Yeah, Morton and Getty is a real reputable law firm in Rock Hill. So I called them up and said, hey, I need defended, because I've done other business with them. And they very rightly so said, we have a conflict of interest. And I didn't know what that conflict of interest was until I read that they're the ones appealing it. So all that says to me, and I got no facts to base it on, is that this is nothing that just popped up. They've been planning this for quite some time. And I believe that it will continue further. Thank you very much.
Thank you, sir.
I would also just like to add some history for those of you who may not have been on the commission. The applicant prior to this did come back before us to ask us to remove those conditions on the shared septic systems so that they could then develop more lots. So my concern is shared with what some of you have already been saying, that they're going to continue to come back to try and get as many lots as they can fit in there, since they've already come back to remove those conditions, which we denied the removal of those conditions. And
Can I respond just very briefly? And I don't want to get into the speculation, and we're not involved in the litigation. I'm not entirely sure what most of what was presented had to do with the issue before you tonight, except for the point, he keeps calling it high density. 5-acre lots, I think you will agree, is not high density. And the issues with septic, those are all issues that are going to have to be worked out in order to develop these lots. They can't do an end run around those issues. They're going to have to go through the standard process. But I want to focus on the issue before you tonight, which I think is very discrete, and that applies to the definition of an exempt subdivision and whether or not the county will treat this as such under the statute. Thank you.
Thank you, Ms. Blue. Is there anyone else that's in favor of staff's determination? And when I mean in favor, strictly to just what's been presented tonight. Yes, sir. Come on up. If you would, just state your name and address for me.
Yes, it's Mac Pope at 3810 Concord Road in New York. One of the issues that Mark has brought up and other individuals have brought up is with the nuclear station there. The NRC commission, when Catawba was approved, was a low-density housing unit. With us, subdividing these even more, that's going to bypass low density. So what we've got to look at is the gentleman that bought this lot already knew that it was subdivided down to this level here. Why does he now have an issue of trying to subdivide it again? If he wanted to buy it as a resident, no problem. But now he wants to, develop it even more. So what we've got to look at is what is the safety evaluation of the nuclear station there with the bridge that is old as well. The county has already stated that we don't want to improve the roads out there for these developments and everything. If you've gone across that bridge by the nuclear station, you'll notice that it has dropped already. And, with additional traffic, with additional heavy equipment going in to develop this, it's going to hamper it even more. So we do have, as Mark mentioned, roughly 100 residents in that area. Should, heaven forbid, something happen at Catawba, you only got one way in and one way out, unless you go by boat. So, we've got to, if you're going to buy something up front, and if you know what the restrictions are, why are you going to try to go around that restriction? I do appreciate what you guys have done in the past in working with, the safety of this peninsula, the quality of the water in this peninsula, and it is a water source for the whole community. So, I am very much in favor of maintaining what you've already approved.
Thank you, Ms. Pope. Is there anyone else that's in favor of staff's determination that would like to speak?
I speak on a generality, so not a yes or a no.
Come on up. If you would, just state your name and your address for me, sir.
Lewis Wilson, 4175 Concord Road, York. I'm probably the least knowledgeable person in this room as to how this whole thing functions. I've had property on Lake Wiley there, down Concord Road for 38 years. I'm a York County native. You normally, I'd say on most of the cases you deal with, talk about property, land. My only comment, and I'm not going to say I'm in favor or not in favor of how this would go, please, as a planning commission around Lake Wiley, don't forget about the quality of Lake Wiley. Some of these proposals here do, some do not border on the water or do not have waterfront. But please keep that in mind as you decide how things go. That's all I ask.
Thank you, sir.
Thank you.
Is there anyone else that would like to speak that's in favor of staff's determination? All right. Is there anyone that would like to speak that's against staff's determination?
Before you close the public hearing, a lot of people out there, I know a lot of people don't like to speak. How many are in favor of staff's determination, and that's why you're here tonight? And how many are against staff's determination and for the developer who are here tonight? Yeah. Thank you. I just wanted to get an idea of why people were here tonight. Thank you.
All right, and that concludes public hearing. Is there a motion to close public hearing?
I'll make a motion to close the public hearing.
Second.
All right, all in favor?
I'd like to make a motion to go into executive session to discuss this matter.
All right,
Second.
all right, so there's a motion on the floor to going into executive session for legal counseling. There's a motion and a second. All in favor? All right, we are in executive session. Is there a motion on the floor?
I would make a motion to affirm staff's decision. I'm basing it on a number of points. One is that the applicant would still have means to subdivide this property in another manner that's consistent with the regulations, so it doesn't remove their right to develop it. I believe the state statute empowers the county to create rules that can provide for an orderly means of development, including number of lots that can be subdivided at one time, definitions of minor and major subdivisions, and I feel like all of that's been adhered to in this process, and so I would want to affirm their decision.
Second. All right. Greg.
Greg?
All in favor?
Mr. Chair, was there any additional discussion on that?
Any
After-
additional?
We had the motion.
motion and a second.
And the second, and I don't think we opened the floor for any additional
Okay.
discussion.
Is there any additional discussion? Sorry.
Just based on the language in the state statute that if any roads are going to be altered, not just created, I think that's where the county has that extra leeway as well. So, yes, I agree that the staff's decision was correct.
I'd like to add just a little bit as well, being a newer member of the commission. We have a lot of things come before us. I think this is only the second appeal that I've been involved in so far. But all of you folks are neighbors. Undeveloped yet, developed, whether you're living in the address, whether you have plans for what the land's going to be, and I would encourage all the parties involved to try and work through what's going to be a best solution to that area for everyone involved and come to a consensus. Because the back and forth, you're going to come back, you got to file plans, stuff's going to happen with staff, come back to us for another appeal, et cetera, whatever it may be. I think if you all could work through those issues yourselves and decide what does that area really want to look like as a community and work towards that together, I think you'd probably get to a solution and find something that would satisfy everyone involved. That and another $6 will get you a cup of coffee at Starbucks, so for what it's worth.
All right, well said. All right,
Mr. Chair, so you've had the discussion following the motion and the second. I think we need to do the full vote now that everyone's had an opportunity to speak.
all right, so we'll do the vote again. So is it all in favor?
All in favor of,
Favor to affirm.
Right, all in favor? Sorry. All right. Let them clear out. All right, we move on to the second item on the agenda, rezoning 23 dash, I'm sorry, no, wrong one. To the first item, or the second item on the agenda, rather, I'm sorry.
Good evening, Marion Ray, zoning planner for York County. We have tonight just one preliminary plat. This is for Southern Pine Lake, and the applicant is MJ Rooster Investments. They are here this evening if you have questions. So this is a similar situation to the previous application. It was done by individual plat first, and then they had a large piece of land left over, so they had to come in for a preliminary plat to further divide the other piece of land. We'll go through here. We have the vicinity map here. It is on Riddle Mill. It is north of Highway 557, I'm sorry, and south of Oak Ridge Road, up near the kind of the state line there. There is one subdivision in the area. It is kind of to the bottom left. That is Patrick Place. That is on Ridge Road. Go to the overview here of the preliminary plat. It's zoned RUD1. That's the 1 acre minimum lot size. There are 38 lots proposed within the preliminary plat, and the total acreage is 73 acres and 0.71. I did a little close-up here. I highlighted the water areas in blue. You have Crowder's Creek there to the left and kind of toward the bottom. You also have a pond on the land at the top right. There are some little streams through the area that will be delineated further when we have the civil plan review. There are 5 interior roads. We have a large amount of roads for something that's kind of small. We have a lot of bird names, which is fun for me. The major thing to see here is American Bittern Way extends to the north to the vacant parcels. So we have interconnectivity to the north for the vacant land. They're a little restricted, they're a lot restricted by Crowder's Creek for extension to the west and to the south. And the gray hatched areas, the lighter gray, not the streams, are the tree save areas for the development. We'll go through the findings. For the first, the site will be serviced by private water and septic systems. They'll have to have DHEC approval before we can final plat. So that means number 2 has been met on this one. Number 3, the proposed land use and density complies with zoning district requirements. RUD1 zoning has a maximum density of 1 unit per acre. This one has a density of 0.52 units per acre. And then for the TIA, a TIA Tier 2 has been completed and approved by staff. Mitigation is going to be required. And then for number 5, for street connectivity, American Bittern Way does stub out to the vacant parcel to the north, allowing for connectivity to other developments that may happen in the area. But they are still bound by Crowder's Creek and by the developments to the south. But they, SCDOT maintained road, Riddle Mill, they have access through there. Sidewalks are not required and are not provided for this development. They do not have to have open space due to their zoning designation, and it is not provided. However, the tree areas do provide about 20% of the existing trees areas, and the lot is heavily wooded. The tree save areas have been reviewed and accepted by staff. So staff recommends approval for this development. Do we have any questions?
Any questions for staff? All right. Is there a motion?
I'll make a motion to approve.
I'll second.
All right. Any discussion or comments? All in favor? All right. On to the next item, rezoning 23-21.
Good evening, everybody. This is rezoning case 23-21 for Chetan and Manisha Patel at 4020 Black Highway in York, tax map number 15600000012 and 041. The request this evening is to rezone 2 parcels totaling 1.7 acres from NC to RC. And I think this is actually the first time we've actually rezoned anything to RC, which is a new district from the recode. But the purpose here is to construct a new canopy over the existing gasoline pumps. The gas station has been operating at this location for many, many years, probably decades. It is currently a legal, non-conforming use, which cannot be expanded. So they've operated as a gas station. They've been there for a long time. They want to be able to expand that by putting on that gas canopy, which is larger than the current canopy. Therefore, they must rezone the property to a district that allows gas stations. Property is located on Black Highway at the intersection of Highway 5 and Rama Church Road and McGill Road on the western part of the county. Zooming in here, you can see the 2 parcels here. As you can see, the drain fields on the northern parcel, so that's why we're going to have them rezone both parcels for this one. This is the gas station on the intersection there of Black Highway and Rama Church. There's nothing here environmental, there's no streams, there's a very flat piece of property. Zoning for the area, the majority of the area here is AGC and RUD, but you can see the two properties here, zone NC, and below that is a property zone GC, but it's used residential. So it's also a non-conforming use, but it is zone GC. I think it used to be a used car lot a long time ago. Comprehensive plan for the area here is agricultural. And as we know, this is an area for farmlands and timberlands, very low-density neighborhoods as well. But you can have some rural commercial and industrial located at intersections of major roads. Staff is recommending approval for this rezoning here. It is somewhat consistent with the comprehensive plan, but the RC zoning district does allow for these rural areas access to small-scale commercial and office uses, like this gas station here. It's located at the intersection of two major roads, and it already was there, and so its existing use is allowed to continue. Any questions for staff?
Yeah, I just have one. I noticed you're not recommending the properties be combined. Is there,
We're not going to require that. We're going to encourage the staff when they come back in to do that, because it's obvious that the two properties are located together and used together. And so we're not going to make that a condition of the rezoning, but we're going to encourage them to combine that property when they come in to do the gas pumps or the canopy.
Any other questions for staff?
Diane had one quick question. Under G, there's a statement that the curb cut on Black Highway does not meet the York County spacing requirements. Is that going to be a condition of approval, or is that something that they've
So
agreed to?
the code has a provision where if they come in to revise a site plan for an existing site, based upon the percentage of the change, we'll enforce them to make these changes.
Okay.
So we're letting the code determine whether or not they have to do any work, any site work beyond just the gas canopy. So we aren't too sure at this point.
Okay.
Are there any other questions? Is there a motion?
I make a motion to approve.
second?
All right. Any comments? All in favor? All right. On to the next item, rezoning 23-24.
This is case number 23-24 for Ashley and John Cooper at 2354 Bohealer Road in Clover. Its tax map number is 25900000043. The request here this evening is to rezone a 1 acre portion, of a 5.12 acre parcel from AGC to RUD. And the purpose is to be able to create a parcel that only includes the home, and then to recombine the residual with the adjacent property. And I'll walk you through all these in a sec. Property is located on Bohealer Road, also in the western part of York County. And here's an aerial map, and so I can zoom in here and show you there's 2 existing homes, this home here and this home here. This home here, they'd like to be able to subdivide out this property here to 1 acre, and then recombine the rest of this property here with this property over here. These are family, and they would like to be able to have a smaller lot here, and then, like I said, recombine that one to the next lot over. The property does have some slope. As you can see, it's a very narrow, long lot. There is also a creek and some floodplain towards the rear of the property. Zoning for the area is predominantly AGC. There's a very little bit of RUD on the northwestern part, and 1 small lot of RUD just to the east of that property. But here, as you can tell, these are mostly large lots in this area here. The comprehensive plan for the area is agricultural. And as you know, that's typically farmlands and timberlands and very low-density residential development, and you can't have some rural commercial at intersection of major roads. For this one, staff is recommending denial. As you know, we have received many applications for properties to be rezoned to going from AGC to RUD to be able to carve out a 1 acre lot. And when we review these applications, we're looking at a few criteria. We want to make sure that there's non-existing farm, that they're no longer going to be able to have that farm use. Well, this case here, there's not an existing farm. But we also want to see what is the current development pattern for that area. Are there already lots in the area already zoned RUD, or 1 acre parcels, or less than 5 acre parcels? And in this case, as I showed you on the previous map, it's not that way. This area has not established a development pattern of these little smaller 1 acre lots. And that's why we're recommending denial of this application. Any questions for staff?
I do have some questions about
Sure.
this. This is my district, and the family did reach out to me regarding this, and there are some extenuating circumstances surrounding it. Is it the 1 acre lot? If it was extended out to a larger, would staff be more apt to want to approve it? Is it just that it's the 1 acre? Because I know, like you've said, we've done this multiple times, especially for people that are within the same family, which is, I know, the situation with this. So,
Whether it's 1 or 2 or 3, it really would be the same. This development pattern for the area, I had to look around, there really aren't any lots that are even less than 5 acres, much more than that. If I kind of bring you back out to here, if you kind of compared that blue area with what's around that, you don't really see anything that's like that blue area in the general vicinity. And that's why we weren't supporting of this one. And I understand there's conditions, I understand that.
and there are extenuating circumstances in this situation, which I am, and normally I would wholeheartedly agree because I try to preserve the AGC as much as possible. But I do know, as the family reached out to me, that there are extenuating circumstances with a builder who is not doing what they are supposed to be doing, and it's put the family member in a bind as far as being able to complete the house, and they're currently having to pay, 2 mortgages, and they may possibly have to sell, which then, of course, makes it difficult because it's family land, and it's just been a really hard situation for them.
All right. Are there any other questions for staff?
And you do have if we do approve this, there is a condition, is that right?
That's correct. It's on the bottom of that screen there. If you do choose to approve that, please make sure you have that condition in your motion. It's a typical one. Make sure you subdivide within 90 days, standard for our split zone districts or lots.
I would like to make a motion to approve with staff's recommendation.
Of the condition.
I'm sorry,
With
yes,
the
condition, thank you,
All
condition.
right, so there's a motion on the floor. Is there a second?
I'll second that.
All right. All in favor?
Discussion, perhaps?
Oh,
Discussion.
all right, discussion. Jump the gun. Discussion, is that any discussion? All in favor? All opposed?
John, you were in favor? Yes. Okay, thank you. Yeah, you were delayed that hand, there you.
All right. So moving on to the next item, 23-25.
This is zoning case 23-25 for the Warren Norman Company at 3151 Highway 21 in Fort Mill. It's tax map number 721-0000003. Mr. Zero. Requested to rezone a 7.60 acre parcel from UD to GC. And the reason for this is to construct a 2-story indoor storage facility with an enclosed RV storage building as well. Property is located on Highway 21 in Fort Mill, just north of Region Parkway and east of I-77. Property over here is currently vacant. In the area here, I've included the site plan for what they're proposing to do. They're only at this point developing the top part of this property. I have heard there are some considerations for the bottom part as well in the future. But in the area here, you have an existing storage facility over here. To the west, this is the Ross Distribution Center. There's also a split center here, an anchor grocery store anchor property here, and also some strip center there as well. Relatively flat, no water features. Zoning for the area. The majority of the area is currently UD, but the other main zoning district here is GC. And so you see a lot of that red area here, which is GC. The comprehensive plan for the area here is I-77 corridor. And as we know, this is for areas located with easy access to the interstate that serve economic generators of York County. They benefit from a campus-type environment with attractive green spaces, and they integrate retail, restaurants, and services in our residence and mixed-use setting. So we are recommending approval for this application here. The request is somewhat consistent with the comprehensive plan and the future land use map. We typically do not support GC as the preferred zoning district for I-77 corridor. However, in the area here, they already have GC located nearby, adjacent to, across the street, and they already have similar uses within the general area here, and it's also will take away one more UD zone parcel. So we recommend approval.
Any questions for staff?
Could we go? Yeah.
No, go ahead, go ahead.
I just wanted, the map again. Do you have one? I didn't quite catch it. Did we have one that shows the zoning of the surrounding, or?
There you go.
Okay.
So this is all UD through here, and then this is also UD. But it's a mixture of uses, as I told you. It's, this is actually a mobile home park. So you have that in UD, then you have other storage
Right.
units in UD as well.
Yeah,
But the
more
rest
I
of
was
it-
trying to get that sense of, when you said there was GC nearby, all of
Yeah,
that red
all
is
that red is
GC.
GC.
Okay, thank you.
No questions, just comments.
Okay,
So, my wife has lived in this area since 1984. She actually was in Twin Lakes for many, many years. It's almost impossible to turn left out of Twin Lakes right now. When the new road's built, different story. There'll probably be a light there. But right now, it's so congested. And people coming out of this storage facility, I hope are patient, because it's going to be worse when you line up with Twin Lakes, which I'm assuming, Diane,
Line
you
up with
would.
that.
Right. For one, they won't have a light there. Not sure if one is in the plan for, we don't know,
I doubt it.
but probably not, which is going to increase the safety concern for me. We've got buses coming out of Twin Lakes also, and most of them turn right, but some of them turn left. This has been on the TIP or whatever since 2010. It should have been started in 2010. Now we are in 2023, and we've had so much development along this corridor. It is terrible in the morning. If there's a traffic accident on 85, it takes 2 hours to get through here, if it's really bad. But I just wanted to comment on it. I do have a question for you, Diane. Has there been a TIA? It said, I couldn't understand. Has there a TIA been done or not?
Not yet.
Okay.
No.
So, but just wanted to throw those comments out there, and
All right. All right. Any other comments? All right. Is there a motion on the floor?
I'll make a motion to approve.
I'll second.
All right. All in favor?
Oh, we need to
Discussion.
ask if there's any discussion.
Discussion. Is there a discussion? Any discussion? Now all in favor? All right.
Any opposed?
Any opposed?
There you go.
All right.
Motion passes.
All right. Tracking sheet. Any questions on the rezoning tracking sheet?
It's for your information.
No. Is there a motion to adjourn?
I'll make a motion to adjourn. Second.
All in favor?
No discussion.